Now we turn to objectives 5 through 9. They include 5. List 5 rationales or justifications for criminal punishment. 6. Explain the purposes of pre-sentence investigation reports. 7. List the legal basis for appeal. 8. Identify the type of crime for which death may be a punishment. 9. Summarize the 3 major procedural reforms the U.S. Supreme Court approved for death penalty cases in the Gregg decision. Criminal sanctions are penalties for violating the law. Courts generally justify them with 5 main goals. 1. Retribution, punishment as payback for wrongdoing, rooted in the idea of just deserts. 2. Incapacitation, restricting offenders' freedom to protect society, such as through life without parole laws. 3. Deterrence, preventing crime through the threat of punishment. Specific deterrence targets individual offenders, while general deterrence aims to discourage the public at large. 4. Rehabilitation, correcting offenders' behavior through education, training, or treatment so they can return as law-abiding citizens. 5. Restoration, assisting victims and repairing harm, supported by state victim rights laws and federal funding. PSIs help judges choose appropriate sentences and classify offenders for treatment and security. After the report is submitted, the defendant may address the court, allocution, challenge PSI information, or request a pardon. Convictions can be appealed on legal or constitutional grounds, but new evidence must have been previously unavailable. The death penalty dates back to colonial America, where laws varied by colony. The first execution was in 1608, Captain George Kendall, for spying. About 20,000 executions have occurred under civil authority, with women making up 3% and juveniles 2%. From 1990 to 2019, the U.S. was one of 7 countries to execute offenders for crimes committed under age 18. In Furman v. Georgia, 1972, the court struck down existing death penalty laws for being applied arbitrarily and discriminatorily but did not rule capital punishment itself unconstitutional. This decision voided laws in 35 states and commuted over 600 sentences. In Gregg v. Georgia, 1976, the court upheld new statutes with structured guidelines. Later rulings limited the death penalty to certain crimes and barred it for the intellectually disabled, mentally ill inmates, and those under 18 at the time of the crime. The Gregg reforms include 1. Bifurcated trials, separate guilt and penalty phases. 2. Guidelines, lists of aggravating and mitigating factors to guide sentencing. 3. Automatic appellate review, mandatory review by the highest state court, with possible proportionality checks. Capital cases also have both state and federal collateral reviews. The 1996 Anti-Terrorism and Effective Death Penalty Act aimed to speed up these appeals. Since 1973, 392 death sentences have been commuted, and 509 inmates have died while on death row. Professor Rees and I hope you have a wonderful day.